What I'm going to do here tonight is primarily try to educate and answer questions and fill people in who may be unaware of what's going on economically, unaware of what's going on with their bank, unaware of the consequences of the October 2008 bailouts, and introduce you to us at Butler Liberty Law, and hopefully just give you a little education on foreclosure, evictions. If it turns out that you end up being our client, great. But really what I want this to be is primarily a public service. Tell you what's out there, because it is rough. It's a rough playing field, and you really have to know that whether or not you get associated with us. This is me. This is at least what federal Judge Patrick Schultz thinks of me. Butler attracts clients through a website that blatantly misrepresents Minnesota law and attacks the legal system, the banking system, and other targets. Butler has been quite successful in attracting clients who either do not know or do not care that he has never actually wanted to show me the note. I gotta address that. The fact of the matter is there's one case in the history of Minnesota law and one case in the history of mortgage securitization law that I'm aware of, and I won it. And we'll get to that later, but it's a case called First National Bank of Elk River versus IMS. And it was a declaratory judgment action where I was representing a bank. And I voided 2 securitized mortgage assignments. Now, it wasn't a show me the note case, and none of my cases are. But anyway, we'll get into this in a little more detail. I just want you to know, for people out there who haven't heard of us and aren't aware, I want you to know very specifically what these fellows have said about me and ladies have said about me. When Butler's claims are finally challenged on the merits, he makes false representations and spins out contradictory and often absurd arguments in the apparent hope that their sheer weight and number multiplied by the number of parties and claims will overwhelm his opponents in the court. None of my claims have ever been challenged on the merits, at least in federal court. They've all been dismissed on what's called a Rule 12 motion on the pleadings. We've never gotten to the merits. We've never gotten discovery. We've never been allowed to lift the rock on any securitized mortgage in federal court. And so that has just never happened. And this is where Judge Schultz is actually kind of nice to me, because he says, Butler's actions are not the result of negligence, but Butler is very smart and very aggressive lawyer. And then at the end here, what happened in our first version of Quiet Titles, I walked into Judge Schultz's courtroom at 7:30 in the morning, and without any hearing or anything, he said, Mr. Butler, come to the podium. And for 3 hours, he grilled me on my complaint, and I explained to him exactly what I'm going to explain to you here about securitized mortgages and quiet title law. And at the end of it, he, as you can see, sanctioned me $50,000. I haven't paid it, and I never will pay it, and I don't have the resources to pay it. But you should also know that sanctions in courts, if a lawyer does something, it kind of breaks the rules or does something blatantly dishonest, there's a procedure for that, and usually it's brought by the other side. Prior to that, not one lawyer of any bank brought any sanctions motion against me. Why? Because I think they know the truth. They think they know that what I'm going to tell you tonight is correct. But for whatever reason, whether it was because we were representing such a burden on the federal courts or what, I don't know, but that was a start of a very, very bad spell for Butler Liberty Law, getting sanctioned $50,000. And it wasn't just Judge Schultz. Judge Ann Montgomery, she sanctioned me too, said Butler's insistence on relitigating losing arguments is staggering, and it comes with a cost because it multiplies the expense of litigation. And this is what disturbs me, and monopolizes scarce judicial resources, as though you're not paying for that. Moreover, no one, not even Butler, can reasonably or competently believe in the merits of any of these arguments. Yes, I can. I won a case. I won a case called First National Bank of Elk River versus IMS involving two securitized mortgages. I can legitimately believe in the theory that was attacked here. And then, as you can see, she went on to sanction me too. And Butler's refusal to dismiss a complaint, which never had any hope of succeeding, as well as his filing of frivolous remand motion, deserves sanctions. Plaintiff's entire claim in this case is based on a legal fallacy that plaintiff's counsel, William Butler, Esquire, has doggedly refused to acknowledge. Butler has invoked a cruel arousal of unrealistic hope in his clients, all of whom face foreclosure and for whom this is an extremely emotional issue. There. If you sign up as my client, don't say I didn't warn you. Why are we in the foreclosure crisis? Thy silver is become dross, thy wine mixed with water. Our money is being destroyed before our very eyes. Our money has become disconnected from anything from real value, and this started, of course, with the establishment of the Federal Reserve in 1913 and really went off the rails starting in 1971. As a result of that, this is just truth. Thy princes are rebellious and companions of thieves. I mean, is there anybody who has any trust in elected officials? Those are our princes today. These are the people who signed the October 2008 bailouts. These are the people who rewarded the banks that created the problem and then tried to paper it over with printed money. And this is the problem. And mark my words, we will come back to a system that has sound money. It will happen. This is proof of Isaiah 122. You can see the loss in the purchasing power of the dollar from 1913 down to today. And if you really look at 1971, the wheels came off the cart in this country morally in 1971. People have lost their compass, and particularly lost their compass as of 1971. And really sadly, coming to this realization for people is sometimes a very, very difficult thing. Every day I deal with and represent people who are just waking up to this fact. These people realize that, oh my gosh, I've been participating in a system where I've been chasing these dollars or doing things for these dollars, and it really isn't me. I'm not, fulfilling myself. I'm not doing what I needed to do. And that's what happens in a funny money system. Bubbles get created. The government says, we're going to subsidize housing, so I'm going to go be a carpenter. I really want to be an artist, but the money's over here. And then all of a sudden, the bubble pops. I'm economically displaced. I can't tell you the number of poor fellas, especially guys from 45 to 65, who come in my office who think they carry all this guilt of, oh, I'm a loser, I'm a terrible guy. You know what? No, you're not. Somebody was sticking a shot of vodka in your orange juice every single morning in causing you to make dumb economic decisions. And that is evidence of it. And until we can get back on track and get the wheels back on the cart, we're not going to stop fighting. For the people out there who think that, and a lot of people who are of my bent, I'm an Austrian economist worldview kind of person. There's a lot of people out there who think that we're on the upswing right now, that because the Federal Reserve printed a whole bunch of money, things are going to get better. Look at that. If you measure production in something real, gold, we're down and we're going down. And the quicker people wake up to that fact and say, okay, I've got to figure out what God put me on this earth to do and just start doing it, the better off we will be, and the quicker we will start going upwards. This is my pet project of valuing things in gold, and this values the stock market in terms of gold. And let's say the stock market goes to 30,000 tomorrow, and the New York Times and the Star Tribune says, "Hey, awesome! The stock market's 30,000. Happy days are here again." What you're going to see there, if you measure that in terms of gold, you're going to see gold probably get to $30,000 an ounce, and then loaves of bread are going to be $30. But it takes time for that to happen, and it's a product of the manipulation of the money that has no basis in value. This is a really interesting one, actually, and I kind of want to explain this. This chart measures M3. M3, it's a measure of money that the Federal Reserve discontinued in 2006. First of all, what is M3? M3 is the kind of money that essentially gets created out of thin air, like a credit card. And you can see in 2006, M3 started to go off the charts. And what happened is the people who have the license to print that money, they were getting into securitizing loans so much that chart went exponential. And the Federal Reserve said, oh my goodness, we've got a problem. And so money was getting printed, created out of thin air, and there was no oversight. The banks are subject to what are called reserve ratios. They can create that money, but it has to be within certain limits. Like if they've got $10 in the deposits, theoretically they're limited to loaning out 100. It's a 10-to-1 ratio. I think, again, the wheels went off the cart in terms of credit-created money in 2006, and that shows it. Okay, so now we're going to turn to just some mortgage loan basics. This is an old school mortgage loan. You got your borrower, average Joe, and then you've got a lender. If anybody's ever seen the It's a Wonderful Life, it's Bailey Savings and Loan. You went to George Bailey and said, "George, I need a loan." George said, "Okay, here's $100,000. I'm going to take a mortgage in your house." So you showed up at the closing, you signed a promissory note to Bailey Savings and Loan, and that's your promise to pay. And then you also signed a mortgage, which is security for the promise to pay. And 10 million years of real estate law will inform you that a note is a promise to pay, it's a negotiable instrument, and a mortgage is security for that promise to pay. A mortgage without a note is nothing. That's been really twisted in Minnesota law, but it's still true. Okay, so this is a securitized mortgage loan. Now you have a borrower, average Joe, and of course, since we're in Minnesota, we have above average Joanne. And then it gets more complicated on the lender side. We've got a mortgagee, you may have heard of like MERS, and or the original lender. We've got a lender who can either be the actual lender or can just be someone like Joe's Bait and Mortgage Shop, just a mortgage broker, somebody who just showed up at the table who was fronting for someone with the real money. And then ultimately you have the real lender who is a mortgage-backed securities investor. Okay, this is how a securitized loan works. Joe and Joanne sign a note and mortgage, and they sign it to whoever's across the table from them. That might be Joe's Bait and Mortgage Shop, it might be Citibank, it might be Bank of America, Countrywide, whomever. And then it goes into the pooling and servicing agreement. This is a securitization document. Within that pooling and servicing agreement, there are several entities. There can be a sponsor, an originator, and then a depositor who ultimately deposits the loan with a trust. And there's a trustee who's in charge of the trust. The mortgage-backed securities purchasers, these are the Wall Street pension funds and whatever, they're pumping money into the pooling and servicing agreement, and they want to know that their mortgage-backed securities are backed up by something, that there's something real that I'm buying into. And the way these agreements are set up is that to give the mortgage-backed securities purchasers assurance that what they're buying is real, the pooling and servicing agreement sets up a trust. And they say, we did this, we've got this all right, we've dotted our I's and crossed our T's, all the notes and all the mortgages, there's 40 billion of them here, and we got them all in a trust, and they're locked in a safe in Delaware, and you're cool in giving the money to us and passing it through to average Joe and Joanne because we got their notes and their mortgages in a locked box somewhere. But in order for that note and mortgage to be valid, or for someone to foreclose on it, if that trustee is foreclosing on it, for example, then what has to happen according to the pooling and servicing agreement, these arrows from A to B to D to T, those arrows represent terms of the pooling and servicing agreement say that both the note and the mortgage have to be transferred to A and B and depositor to T. And it further says, the pooling and servicing agreement, that those entities, while they have those notes and mortgages, have legal title to them. Nobody ever sees this of record, but this is a chain of title. And if T is holding your note and mortgage, and they weren't endorsed by A, B, and C, or there aren't assignments of mortgages, then there's a problem. There's been a breach of the pooling and servicing agreement, and my argument with federal judges is they will come back to me and say, well, so what? You're not a party to that pooling and servicing agreement. You don't even have standing to make that claim. That's all a bunch of Wall Street mumbo-jumbo. But the fact of the matter is, if trustee shows up at my sheriff's sale, what does he do? He bids in a $300,000 debt due on a note. Okay, well, what if that note is sitting with entity B? And what if entity B sues me 3 years later on a $300,000 claim? Where's my recourse? Because all that foreclosure stuff we talked about, remember the deal between the banks and the legislature, we're going to let you do this outside of the judicial process. We're going to give you the privilege of doing this. It is a big deal. And it's not just a theoretical deal, because we've had clients on second mortgages. So it's not just theoretical. And by the way, Minnesota Attorney General, I think yesterday or the day before, came out with some big press release that she's going to go after or support legislation that will require kind of the little dog bill collectors to prove up ownership of the debt prior to making claims on credit cards. I think Midland was one of her targets. Well, okay, great, Lori, but what about Citibank? What about JP Morgan Chase? Why don't you go after the big dogs? This is a representation of a securitized loan. The green level is what you see. You show up at a closing, you borrow $387,000 from you think Countrywide, and you sign a note payable to Countrywide, and then you sign a mortgage also to Countrywide, but sometimes there'll be a third party, what's called a nominee, maybe MERS. So this is using a kind of a Countrywide securitized loan as an example. And then when you hit foreclosure, what there will be is, say, Bank of America acquires Countrywide. In order for Bank of America to commence the foreclosure on you, they've got to get an assignment to that mortgage, and they do. They'll have somebody from MERS, a MERS vice president, maybe a local lawyer, assign the mortgage to the client, Bank of America. Second level, you also see that. So this is a servicer. So this is who you pay. And if you went back to that other slide, that was the servicer in that big bubble. They're kind of the chief operating officer of a pooling and servicing agreement. They make securitization go. They collect the dough, they pass it out to the mortgage-backed securities purchasers, and so that's who you pay. And that can differ than the green level. You can have 5 or 10 of these servicers and sub-servicers at the red level. And in this case, we just went from Countrywide to BAC Home Loans, and then ultimately to Bank of America. This final level is what you don't see. You don't see this securitization part, this kind of purple in the middle. These are the, if you went back to that other slide, with the A to B to T. So these are the entities that had interests, legal interests, in your note and mortgage. And the securitization documents will always require that the note be endorsed by AmeriQuest Mortgage and also then be endorsed by AmeriQuest Mortgage Securities, Inc., and then by Bank of America as trustee. And it would also require that there be assignments of mortgage to all of those entities. And again, remember, that's what the mortgage-backed securities guys, the investors, they said, we need that. If anybody's touching this stuff, we need to know that they've signed off on their title. And then sadly, at the end, what's really happened as a result of the October 2008 bailouts is Fannie and Freddie, I think, are in on about 80% of all securitized loans now. The FHA is originating loans. They're trying to prop up the real estate market, printing money as though that is going to somehow make gravity not work. Now, this is the response to all the attacks at the beginning. You know, Butler does this. He makes up these silly claims. He's got no basis in law or fact. I'm not sure if any federal judge out of those 22 actually cited the statute that we proceeded under. Maybe, I think Schultz did actually in a footnote, but that was the whole case. It is our case. Chapter 559 allows for a quiet title action. If you can see the bold, anyone may bring an action against another who claims an estate or interest therein or a lien thereon adverse to the person bringing the action. Frivolous, I guess. So this is just one. This is the recent 8th Circuit decision that was favorable to us. Again, we had 22 quiet titles. We lost 0 for 22. The first one that the 8th Circuit decided, they reversed. They said, Butler, you stated a claim, but it's not as good as it sounds. They hated about 85% of the complaint. They called it Show Me the Note and said, but we think you stated a claim for unrecorded assignments of mortgage and robo-signers, and so we'll send it back down to the district court. So there's a big celebration up in the office. People were like going nuts, like, oh, we won, you know, the $250,000 of sanctions will go away, which they will as a result of that. So that's a big weight off the shoulders. You know, Chief Judge Arnold of the 8th Circuit says you stated a claim, so the sanctions should go away. But it really is kind of a backhanded, the way they wrote the opinion, they basically said, okay, we're gonna let this guy's neck out of the noose, and we're gonna send it back to the district court, and so you can screw him good. And so what we're going to do with that decision, even though we won, we're going to petition for review to the U.S. Supreme Court, because we're not going to accept a crumb, and we're not going to accept a half a loaf. So that's Murphy v. Aurora. That was the big win that we were kind of, you know, bringing people in here to celebrate. But it became apparent to me in the last week that the federal district court is not going to celebrate it as a big win. It went back down to the district court. I had a scheduling conference Monday. Okay, I won, right? The local federal district judge says you don't get discovery. You don't get to take any depositions. They get their next bite at the apple. I would be very surprised if Judge Montgomery says, yes, okay, I accept there's a claim here. But if she doesn't, we're going to be very prepared. It's going to get reversed again. Okay, these are other cases, other quiet title cases that basically say the summary of these cases is that in order to start a quiet title action, that you just need to be in possession of the real property and allege an invalid lien on the property. This is old school stuff. And then, like the case I tried, the First National Bank of Elk River versus IMS case, the party asserting the lien actually has the burden of proof in that case. They've got to come in and show up their lien, prove up their lien. And it dawned on me when this whole securitization, this whole mortgage crisis occurred, I said, you know what, they can't prove it. And the deeper I got, the more I'm convinced they can't prove it. That transfer to A to B to C to T never happened. It never happened. And a quiet title allows you to lift that rock and say, show me all the bugs. And if the bugs don't perfectly align in your favor, then you have to go away. You don't have a lien. You might have a note, and you can sue me on the note, but your mortgage is gone. And then we can have a fair fight. So these I don't think any federal judge in any of those 22 cases cited any of these cases. Maybe Schultz did. I know that none of them have cited, or I don't know, but I'm 99% confident that none of them have cited Alt v. Graf. That's the burden of proof case. This is the burden of proof in a quiet title. This is, you saw the first screen, turning the tables. A quiet title turns the tables. It requires them to come in and show that their paperwork is correct. And that's why the federal courts hate these, because it turns the tables. And it will require a lot of work on the banks to prove up their position. Is that nasty of me to do? I don't think so. I would love if they would all come to me and negotiate. We could probably come to a reasonable number for clients. But that is the law. And that's just the site to First National Bank of Elk River versus IMS. It's linked on my website. You can pull up the case, you can read the case, you can see what I argued to federal judges, every one of the judges who dismissed my cases and sanctioned me. I said, these cases are no different than First National Bank of Elk River versus IMS. The federal judges say, you're saying, show me the note, show me the note. I'm saying, I don't care if they show me the note. If they don't show up with the note, they lose. Just like in that case, I was representing First National Bank of Elk River. Independent Mortgage Services had 2 recorded assignments of mortgage. They said they were the owner of the mortgage. We said we were. We had notes. We won. They didn't. They lost. Simple. The Murphy decision said, and this is a difference between what we were doing before and what we're doing now. The Murphy decision said, okay, Butler, you stated a claim when you say that there are unrecorded assignments of mortgage and there's robo-signers. And again, I'm fairly characterizing it, it's a 10% win. But as I explained to 2 courts today, it's still a 100% win, because the purple blue level down there, that's the disease. Okay, that's the disease. I've been talking about that forever. That was all quiet title 1.0. That was pre-Murphy v. Aurora. I was talking about the note wasn't assigned and Fannie Mae doesn't have any right to enforce the note, so what are they doing showing up at the sheriff's sale, or even Bank of America? The note wasn't endorsed. They don't have any right to show up at the sheriff's sale. That's the disease. The note is what drives a real estate transaction. Federal courts have sanctioned me for using the 4-letter word note. So Murphy now says, well, if you talk about unrecorded assignments of mortgage and robo-signers, you may have a claim. Well, that's just a symptom of the disease. In every single securitized mortgage case where there's been a bad transfer of a note, there is an unrecorded assignment of mortgage and there's a robo-signer. And so we'll show you in a minute kind of some of our work. And that little line at the top, that assignment of mortgage, is always, that's the devil right there. That's always where the problem is. Because imagine you're Bank of America and you're holding a big bag of countrywide crap, and your notes aren't endorsed, your mortgages aren't, you don't have assignments of mortgage, but you got to foreclose. Well, in order to foreclose, I got to have an assignment of mortgage to me. And then you look around the room at all the, suit vice presidents and say, who's going to sign the assignment of mortgage? Not me. That's bank fraud. So what do? You go hire some 16-year-old, and then you get her to say she's a vice president of MERS, and, oh, hey, China Brown or whomever else, sign this assignment of mortgage to us. And so it's there every single case. We pull up 500, or not 500, but probably 250 doc outlines, which we'll show you in a second, and they've all got that flaw. So the symptom is everywhere the disease is, and so even though Murphy is a 10% win on its face, it's a 100% win. Okay, and I have to address this because there was a case called Jackson v. Mers that was decided, I think, in 2009, and it was a long case, and I had so much difficulty explaining to so many judges why it had no applicability to my cases, but I do want to address it here. And I still don't think it has any applicability. It wasn't a quiet title action. There was no Chapter 559 action. There was no Alt-V graph, burden of proof switching element to it. There was no bank defendant in that case. But it was a long discussion of Minnesota law, and there are two things that I think are incorrect about the decision. Even if it is the law, these are what it says, but I think that they have no basis prior to Jackson v. Mers. The first one, that a mortgagee need not have an interest in the note in order to foreclose by advertisement. What that would mean is, if that were true, and that, again, that's what Jackson v. Mers says and has been interpreted to stand for or be the holding. If that were true, that would mean that a complete stranger to the note, okay, you signed a note to Countrywide for $300,000, and then Daffy Duck showed up at your sheriff's sale and bid in $300,000. Daffy had no interest in that note. So, and there's no support for that. There's a couple of cases in Jackson v. Mers. There's a Botno case and another case, I think, where maybe a lawyer was acting as an agent for the note holder and he foreclosed, but he was clearly, and he was of record, an agent. It's okay for an agent to foreclose. Like, for example, Mers potentially could foreclose if we're an actual agent, if we're actually operating on behalf of a note holder, but it isn't. And so that, I think, is incorrect. The other thing that we haven't challenged, and we never will, but I just want to go on record, it says that the note does not follow the mortgage in the sale or transfer of a note. Now, this is kind of legal arcane stuff, but every single pooling and servicing agreement that was established is covered by a legal opinion by a law firm. The biggest law firm that did this was a law firm called, I think, Layton and Fingers, or Fingers and Layton in Delaware, that signed off and said to all the mortgage-backed securities, it is our opinion that the mortgage follows the note. So you don't need to worry about those green levels, that only the mortgage is of record and all these transfers happen down here. You're secure, because it's our opinion that every law in every state in the nation says that the mortgage follows the note. So it doesn't matter if I'm the of record mortgagee and I transfer the note to Talitha, to Matt, to Suzanne. When Suzanne wants to foreclose, she can foreclose. She's going to have to get an assignment of mortgage from me to her, but as the note transfers, the security transfers to her, even though there's a difference there. So it's still in my name of record, but she can feel comfortable that if she holds the note, that she's ultimately going to be able to execute on the security instrument. This is the actual holding in Jackson. In Jackson, what the plaintiffs were saying is, well, that those transfers of the notes, they have to be recorded in accordance with the Minnesota Recording Act. And the court held, no, they don't. Okay, this is why Jackson doesn't apply to what we're doing. It's not a quiet title action, not an action under Chapter 559. The burden of proof was on the plaintiffs, not on the defendants. No bank named as a defendant. No challenge to title. It was an attack on MERS and the splitting of notes and mortgages. That's not what we're doing. And so this is, I'll just lay it out there. This is going to be our quiet title 2.0 theory. The Murphy court says unrecorded assignments of mortgage are in play. Unrecorded powers of attorney are in play. Robo-signers are in play. So that's what our quiet title 2.0 legal strategy is all about. But this is, if you come into us And you don't want to start a quiet title, but you kind of learn what's going on with your loan and where we would see the flaws are. We do this up, we call it a document outline. And this is just a sample quiet title lawsuit. This is a quiet title 2.0 lawsuit. All we're really wanting to get is, we don't want to get a free house, but we don't want Fannie to get a free house either. We're really trying to, get some old school due process, some pre-1971 sanity. And if we got through the door on one of these, I think more what's holding us back is, maybe I'm not a good voice or whatever, but there's a lot of fear of rattling the established order. This is what happened in 2008 and the storm that's coming, and you need to prepare whatever you need to do. Get in shape, do whatever. But our monetary base tripled since 2008. What that means is that we're going to be faced with, or I suspect, unless there's something that they can do to curtail it, and they will try to curtail it, but we're going to be faced with some serious inflation. The way they've kept it under wraps so far is they printed all that money, but it's sitting with the bailout banks. Well, why aren't they lending? Because the Federal Reserve has done something called pay them interest on excess reserves. So you're a bailout bank and you're holding, say, $1 trillion, and you look out and you see no businesses worth lending to. But even if you do, the Federal Reserve says, hey, if you put that $1 trillion with us, we'll pay you 0.1% interest, or but it keeps that money off of the streets. And they've been very, very effective in keeping that off of the streets for 4 years. But now, the presidential election has happened, that money is going to hit the streets. And when the Federal Reserve wants to, if it flips the switch and says, banks, now we're going to charge you rent, that money is going to fly out. And loaves of bread the basics will go up. How will the government respond? Price controls, blame the baker, things like that. And then stuff comes off the store shelves. But that is a serious crime that occurred. And we are going to see it in the next few years. I don't know when or how, but you need to be concerned about that. You need to, these dollars, you saw those charts at the beginning where dollar was losing its purchasing power? That is a real loss of purchasing power. When dollars get multiplied, they lose their purchasing power. If you're sitting, on $100,000 in cash, get it in something real.